Good afternoon, everyone. Welcome to CDH and our Companies Act Development Seminar. A special thanks for joining us in person. I must say it's a huge pleasure to see so many people together at one of these seminars. So thank you very much for taking time out of your day to join us. My name is Ian Hayes, and I head up CDH's corporate and commercial practice area. As a team, we offer to you, our valued clients, in-depth expertise and experience across a range of commercial sectors. We take pride in understanding your commercial imperatives and business strategies. We thrive on partnering with you to deliver best-in-class legal advice that results in pragmatic and winning business solutions. We have offices in Johannesburg, Cape Town, Stellenbosch, and Nairobi in Kenya, and it gives me great pleasure to announce today that we will be opening an office in Namibia, in Windhoek, on Thursday. So 2 days. Today, in unpacking these developments around the Companies Act, we hope to support you in making company law clearer, more user-friendly, and ultimately facilitate the ease of you doing business. Our panel of experts, all sitting up front here, will take the lead in navigating you. But please don't hesitate to reach out to us when joining us afterwards for refreshments on the deck, or later at any time through a call or an email if you have any queries. I'll be handing over to Yaniv Kleitman, which many of you may know. Yaniv is a director in our corporate and commercial practice, specializing in company and security law. Yaniv is a leading mind on current law and practice relating to M&A of both public and private companies in SA. With his finger on the pulse of all things corporate and commercial, Yaniv is best suited to open today's seminar. Thank you.
Thanks, everyone. You won't be applauding when I tell you all the disclosures you're going to have to make in terms of remuneration, etc. Okay, thanks everyone for coming through. That's the order of the day and the topics that we'll each present on. Most importantly, I'll focus on share buybacks, regulated companies, and the prescription, the time bar with regard to pursuing directors for fiduciary breaches. I'll hand over to Thandi, who will look at the validation of irregular share issues and also the issues for future consideration, the stakeholder arrangement. Akona will talk about the CIPC filings, the amendments that they've made to the employee share schemes, and aspects around financial assistance. And then very strategically at the end, we've left it to keep you in the room around the remuneration policy, because you all want to know if your directors and prescribed officers are going to be working pro bono, or what's the story there. So, okay, so we'll talk a bit about that. So let me just get straight into the topics that I'm going to address. I think just a bit of an introduction and just a bit of a broad sort of background of what brought these amendments about. The public commentary phase ended yesterday, so I hope you put in your comments. And actually throughout the topics that I'm going to discuss, I will mention where we've actually made submissions on and where we've sort of implored them to clarify and refine the draft bill. It has been over 10 years since the Companies Act came into force, so it is, due time for a review and an update. But really some of the major global trends and sort of discourse and broad principles that have brought these amendments around is obviously enhanced transparency and disclosure, especially around remuneration. And then also say on executive pay, what role or what say should shareholders have on the remuneration of directors and executives. The money laundering and the grey listing, okay, that's already in force. That's the aspects around the beneficial ownership that came into force last year. I'll also talk about that for a bit. And also just some general technical improvements and on the Act. So, okay. So let's get into share buybacks. What What are they doing there? We know currently, this is the Section 48 sub 8 of the Companies Act. We know all buybacks by companies, they're subject to the solvency and liquidity test. And then certain buybacks, which are regulated by sub 8 in Section 48, if you're buying back from directors and prescribed officers, you need a special resolution for that. Okay, so that's as it stands currently. And then there was this section, the subsection that has tortured us for 11, 12 years now, that it says, where you are buying back more than 5% of any class of shares in a transaction or an integrated series of transactions, it's subject to the requirements of sections 114 and 115. Okay, and then when you go and read those sections, you see they talk about schemes of arrangement and fundamental transactions. And so we're talking about here a buyback, a one-on-one contractual buyback with a shareholder or a couple of shareholders. And now the question arises, okay, so when I do such a buyback, is it actually a scheme of arrangement, or is it just subject to the procedural requirements of a scheme of arrangement, namely that you need a special resolution, you need your expert's report for that buyback, and there's instances where the shareholders can apply to court to review that special resolution if it's been passed. And so we grappled with that aspect, and actually the most significant implication of the answer to that question is if you have a regulated company, which I'll get to, if a regulated company is doing such a buyback of more than 5%, and you're going to say that it is a scheme of arrangement and not only subject to the procedural requirements of a scheme of arrangement, well, then you've got an effective transaction. And then it's subject to TRP regulation. You've got to have a circular. It's quite an onerous layer of regulation that you've got to comply with. And so the case that, a series of cases that came close to answering this is the capital appreciation cases, where the High Court said, no, it's not a scheme of arrangement, but appraisal rights still apply, because that applies to all fundamental transactions. Then, about a year later, the Supreme Court of Appeal muddied the waters a bit and said, didn't actually specifically decide whether it is a scheme of arrangement, but it said it is a fundamental transaction, these buybacks, and appraisal rights apply. So that much is clear. Your appraisal rights still apply when you do these buybacks of more than 5%. But not so clear whether it's a scheme of arrangement, because that question is still important for purposes of regulated companies. And I think after the SCA handed down its decision, look, the TRP has always been of the firm view that it is a scheme of arrangement and is subject to their jurisdiction. And I think after that SCA judgment came out, I think that's the predominant view, that's the cautious approach. You've got to go to the TRP. So that's your current position. Now they're overhauling that completely. So they're going to delink it from section 114 and 115. There's going to be no reference to that. The regime that will be now, they've done it a bit clumsily, and I'm not sure why they split it out in the way that they did, but the upshot is buybacks, you will need a special resolution now, and that's all, just a special resolution for any share buybacks. Okay, no experts report, there's no link to 114 and 115 anymore. You're not going to be concerned with appraisal rights or the question of whether it's a scheme of arrangement. All share buybacks subject to a special resolution, except if it's pro rata. It's a pro rata offer to all of the shareholders. Then you don't need a special resolution for that, because all the shareholders are being treated equally. Or if you're purchasing on the stock exchange, if the repurchase is done on the stock exchange. It's not really a carve-out, because in terms of the listings requirements of the exchange, you would typically need a special resolution anyway, either a specific or a general one. Okay, so that's going to be the new situation, pretty much going back to how it was under the old Section 85 of the 1973 Act. Special resolution unless it's pro rata from all of the shareholders, and it's still subject to solvency and liquidity. Okay, so that's the share buybacks. Regulated companies, very welcome change here, although I think they need to refine a few things. So we know if you're a regulated company, you're then subject to takeover law if you're doing an affected transaction, which is those either the fundamental transactions or any other transaction where you're taking control over the company. So regulated companies are all public companies, state-owned companies, and then we've, up till now, we've had this very weird test for when private companies are regulated companies. It's simply, has there been more than 10% of the shares transferred in the past 24 months, okay, amongst unrelated persons? Doesn't matter the size of the private company, what its assets are, how many shareholders it has. You just look at the securities register and you say, okay, in the past 24 months, in aggregate, there's been more than a 10% transfer of shares. Then it's a regulated company. And no one really understood this test where they're trying to catch private companies that had some sort of liquidity or, trading in the shares that is comparable to a public company. But certainly something has always been missing in that test. For a private company to be subject to takeover law, surely you've got to take into account the size of the company, the number of its shareholders, etc., like it was under the old SRP code. And now they're basically harking back to that test. So they're going to overhaul that completely. A private company is going to be subject to takeover law if it has 10 or more direct or indirect shareholders. I'll return to that. And it will have to meet certain financial thresholds which will be prescribed in the regulations to do with annual turnover or asset value. So I think that's a step in the right direction, although I do query what is indirect shareholders. That's a vague concept. They haven't defined it. So now you're going to have a question, for instance, let's say you have, are shareholders of the shareholder company, are they indirect shareholders on the underlying company? Let's say you have a trust, which is a shareholder. Do you now count all the beneficiaries? Are they indirect shareholders? If you have a partnership, a common deed partnership where the general partner holds the shares in the underlying company, do you now count all of the partners? So I think this concept of indirect shareholding they really need to look at. We've submitted there that they've rather got to use the concept of people who hold a beneficial interest in the shares. That's a defined term in Section 1, and I think that's a bit more of a sensible, has a defined sort of concept. So they have to work around that as well. And I think another element which will be they're going to have to address is transitional arrangements. So you're going to have a situation where you're busy with a transaction, scheme of arrangement, fundamental transaction, whatever the case may be, that has maybe progressed quite substantially, and it's in respect of a company which, on the current test, is not regulated because it doesn't have the 10% transfer in the past 24 months. Now what's going to happen is that halfway through that transaction, this bill is going to become law, and now suddenly that company is regulated. And now do you have to comply with the takeover laws? Do you have to kick in the takeover laws from that point onwards? And so we've submitted to them that they've got to deal with some transitional arrangements there. I think it's got to be clarified, at least in the regulations, that if you've got a transaction that has started or commenced, you can debate what that means, but a transaction that has commenced at a time when the company was not regulated, that transaction should be seen through and completed on the basis that it's an unregulated company. You can't now go and apply a takeover law where you've already called shareholders meetings, you've already posted documents to shareholders. So I think that's the other thing that they're just going to have to look at. Okay, so that's the regulated companies. I think broadly, the sensible approach, the principle of capturing large, widely held private companies, good, but there's just things like indirect shareholding is very loose drafting that they need to just work on there. All right, public access to the annual financial statements. I wonder what actually the current position is, because I always get mixed responses and mixed views on this, on access to private companies' annual financial statements. But one of the very controversial aspects that they're introducing here is into Section 26 of the Companies Act, that any member of the public can request to copy or inspect the annual financial statements of certain private companies. Certainly if you're a private company with a public interest score of 350 or more, the public interest score where you get 1 point for every shareholder, 1 point for every R1 million of turnover, 1 point for every R1 million of third-party debt, and then 1 point for your average number of employees. Add that up, what's your public interest score? If you're 350 or more, we know one of the significant consequences of that is that you're required to have your AFs audited. And then the other significance here is that any member of the public will be able to ask for a copy of those annual financial statements. And we're talking about private companies here. And then if you're between 100 and 350 on your public interest score and your annual financial statements were internally compiled, then you're exempted from that, from the requirement. So we're really talking about large private companies will be subject to this. This hasn't, the main consternation about this point, that any member of the public can ask for this, is the remuneration. Because we know with those companies that are required to be audited, they have to disclose in the annual financial statements the remuneration paid to each director and to each prescribed officer, which is your senior executives and managers. And now this bill will make it very clear that that disclosure has got to be on an individualized basis, because what some companies were doing, like in the old Section 297, they were giving aggregate disclosures. They were saying, this is everything we pay to all of our directors or to all of our prescribed officers. That's also going to be changed with this bill. So you're going to have to disclose by name what each director and what each prescribed officer earns. That's got to go into your annual financial statements and will be accessible by the public. And we know from the case law on the access to the securities register, that's the Nova property case, that access is unqualified. It's absolute. You don't have to produce a reason for why you need to access it, and the company actually has no defense. Once the member of the public asks for it, you must give that information. So I think that's the sensitivity around it. There's going to be a lot of submissions on this, and I'm sure a lot of them went in yesterday. We submitted that, for instance, you've got to look at the position in the EU regulations where they say a company can withhold that information, at least about the emoluments, to directors and prescribed officers if it were to disclose the financial position of an individual director or prescribed officer. But just one point here, and I get this a lot, the outcry of privacy, my constitutional rights, Bill of Rights. Those privacy arguments and all of that confidentiality, they don't work in company law. That's because the philosophy of company law is that if you want the benefits and the trappings and all of that of separate juristic personality, limited liability, that's something bestowed on you by Parliament. It's not something you have at common law. It's not an inherent right that you have in the Constitution. So if you're going to have the benefits of limited liability, which is bestowed by statute, you've got to take the good with the bad. That with those benefits come the burdens or disadvantage of disclosure, transparency, and all of that. So please, privacy arguments and all of that, it just doesn't work in company law, and they don't really carry much weight. Okay, so we'll see where that goes. And look, currently those companies have to file at CIPC anyway. It's always been a murky area whether you can actually get that information from CIPC, because in principle everything filed at the CIPC is public. Whether you would have access to private companies' annual financial statements has always been a bit of a murky area, and CIPC's had different positions on that. Now with this amendment, very clear. You can ask it from directly from the company, and it has to give that information. Okay. All right, prescription on directors' breaches. I think this is a very important change. And it's a little subsection tucked away in Section 77 of the Companies Act that I think doesn't really receive a lot of attention. But it has very far-reaching circumstances. And there was one case here, the Nebevest case, that picked up on this point, and I think now they're going to remedy it. Section 77, that deals with the right of the company to sue its directors and prescribed officers for breach of duty, for breach of fiduciary duty or negligence, any of your duties as a director. If that causes loss or damages to the company sues you for that. Nothing controversial about that. And Section 77 codifies essentially what would have been the position at common law anyway. And then there's Section 77 sub 7 that says, okay, but before the company must bring that action against the director for breach of duty, must bring it within 3 years after the act or omission that resulted in that loss or damages. And now when you read that, you see that in terms of the plain language, that's a hard time bar That's a cutoff from the date of the act or omission. It's irrelevant when the company, for instance, learned about the material facts that underlie the cause of action. So we know in terms of our general principles of prescription, and this is very important for creditors, they rely on this time and time again, as you see in the law reports, is the act or omission maybe happened 10 years ago that resulted in loss and damages to me now. But the material facts that underlie the cause of action only reasonably came to my attention now, or maybe a year ago. And then that's fine. That's where the Prescription Act of 1969 says, that's fine, the 3 years will run from when you learn about those material facts, not from when the act or omission was committed, provided you as the creditor acted reasonably and all of that. So, this came to a head in that Nebevest case, which was essentially a derivative action that was sought to be brought by the shareholder, forcing the company to bring an action against the director for disgorgement of profits and inter alia corporate opportunities. But it happened more than 3 years ago. And but in a sort of obiter judgment, the judge says, sorry, I can't help you. This happened more than 3 years ago. There's no, that's a time bar. You can't bring the action against that director. And, that time bar is, I think, very inappropriate in the context of director breaches. We know when directors breach their fiduciary duties, those involve modus operandi which are very hidden, it's very complicated to uncover. Sometimes it's only when you have to restate your financial statements in many years to come, that's actually when you discover there's been breaches of duty. And so they're going to fix that, and they're going to introduce a provision there whereby the court can, on good cause shown, extend that time period, and it will also be retrospective. So even if that breach happened before this act came into force, this will act retrospectively. And it's quite a wide discretion there on the court on on good cause shown. I think 9 times out of 10 that good cause shown will be that I only reasonably found out about the facts now. I think that would be the main reason one would use that section. And so we've seen this relaxation of time bar in other contexts. We know in the Arbitration Act there's a Section 8 that allows you to overcome a time bar that is in an arbitration agreement. That was the Salmon Court case in the Supreme Court of Appeal. And then we know in competition law, the Pickford's case, there was a relaxation of a time bar in bringing a complaint essentially around sort of cartel activity. But the theme that runs through it, so I think a lot of that case law and the analogous areas of law will be relevant in applying this new section sub 7. And it will really be about when did you discover the material facts. I'm not too sure why they didn't just leave this to be governed by ordinary principles of prescription. We've got robust common law on that. As to when claims prescribe and when you reasonably learn about the facts. But they chose to adopt this approach of, no, the Prescription Act will not apply, expressly does not apply, but the court can, on good cause shown, relax the time bar, which is actually a bit wider. It's actually more favorable than the Prescription Act potentially. Okay, so that's the situation there. And that's actually, that's in the company's Second Amendment Bill, not in the First Amendment Bill. Okay, so I think a welcome change there. When that Nebevest case came out, I really struggled. I thought, no, man, this can't be right. And so you think maybe it only applies to statutory actions in terms of Section 77. Maybe it doesn't apply to the common law. I thought about, okay, maybe we must now write into the MOI that the directors waive that time bar. Because it's really prejudicial to the company. But now with this amendment, that problem will essentially go away, and as I say, it will be retrospective. Okay. Then some aspects around the Social and Ethics Committee, enhancing essentially its profile. When you look at the bill, it looks like very extensive changes have been brought on the Social and Ethics Committee. But actually, when you drill down into it, what they've done there, I'm not sure why they did it this way, but they transplanted a lot of the stuff on Social and Ethics Committee that was in the regulations, Regulation 43, they just transplanted it into the statute. And so it looks like, you look a page and a half of changes on the Social and Ethics Committee, but it really drills down to the following material changes on the Social and Ethics Committee. And it's actually relevant really to public companies and state-owned companies, these changes. So your first change there, I don't think this is going to impact really listed companies a lot, because now they're going to say your membership of the Social and Ethics Committee must be a majority of non-executives. Currently, in Regulation 43, it says you've got to have 3 members that are directors or prescribed officers and at least 1 non-executive director on the board. But the listed companies, that's not going to be a problem for them. They comply with King anyway, and all of the members essentially are non-executive, in fact, independent non-executive directors. So that's not going to be major for the listed companies. Remember, public company doesn't mean you're listed. You could be an unlisted public company, which is actually, in terms of governance and size and structure, maybe more akin to a private company. And so, those companies might struggle to comply with these requirements to get non-executive directors onto that committee. It doesn't have to be independent, non-executive, it just has to be a non-executive director, someone who hasn't been involved in the day-to-day management of the company for the past 3 years. So the majority of the members of the SEC of public companies have to be non-executive directors. What they're also going to introduce, this is going to be important for purposes of the annual general meeting and the notice of the AGM, that Social and Ethics Committee is now going to be elected by shareholders. We know currently it's actually a board committee. The board appoints the committees of the members of the Social and Ethics Committee. Now it's going to be at every AGM, you have to elect, for public companies, have to elect their SEC members. It doesn't say it has to be, like with directors, you have the individual, you've got to have the individual director vote for each director. You can't vote in directors in a slate. You've got to vote on each individual director. But that doesn't apply here to the Social and Ethics Committee. You can vote them in as a slate, much as with the Audit Committee. So it's the same. It's now basically a shareholder committee. So those changes essentially just to enhance the profile and the role of the Social and Ethics Committee. Okay, so gleaning from that, what are sort of the practical positive steps and implementation steps that companies will have to look at that is on the horizon, at least from these aspects? First of all, I think you're going to have to look at the MOI of the company. Some reviews and revisions of the MOI will have to be done. You may have a lot of, depending on how your MOI is drafted, but it may have provisions there which hardwire or sort of incorporate the old provisions. So if you've got a clause there that says, yes, share buybacks of more than 5% require an expert's report and all of that in terms of sections 114 and 115 of the Companies Act, you're probably going to have to go and delete that and just refer to, sort of the generic position in terms of the Companies Act. We'll later talk about the financial assistance. So if your MOI is still talking about financial assistance to subsidiaries requiring a shareholder approval, maybe just delete that and leave it to be regulated by general law. So I think there will have to be revisions of the MOI. With the share buybacks, I don't think it changes a lot for the listed companies. They have to get general or special authorities for buybacks under the JSE listings requirements anyway. You may there now have to cross-refer to Section 48 of the Companies Act, which now also requires a special resolution for non-pro rata buybacks. Now that they've done away with the expert's report, I think it opens up the possibility for having, at least in the non-listed companies, a greater possibility of having almost like a standing authority that you pass of shareholders that can be enforced for a year, 2 years to do these buybacks. Because currently that's difficult to do. Because as soon as you're buying back more than 5%, you need an expert's report and all of that. Oh, and by the way, on that expert's report, also now one question which finally will be put to bed is I always get this question when you do the buyback of over 5% in a private company, can you waive that independent expert's report? Because the shareholders don't need it. They know what is the value of the shares. They don't need an expert to go and tell them. And you have this debate amongst the law firms of, is it actually legally permissible for the shareholders to waive that independent expert's report? We've always held the view that it should be possible. Nothing wrong with that. At common law, you can waive statutory rights and benefits as long as every beneficiary of that statutory benefit has waived it in full knowledge and all of that. Others hold different views. Finally, that debate is over because you don't need an expert's report. And you can actually have these special resolutions passed every year as a standing authority to allow the company to buy back shares, for instance, under an employee share scheme or whatever the case may be. So I think there will be more possibility of that. And then obviously your AGM notices will have to now include, for instance, the election of the Social and Ethics Committee members. Whereas previously that was a board matter. And as I say, that's only for the public companies. Okay, so that's on the bill. Then beneficial ownership. This will be the death of me, beneficial ownership. What they've done here. But let's unpack what they've done here and what they've tried to achieve and what they have in terms of the actual wording. I think this is a provision of the Companies Act which they are going to have to revisit and amend in due course. So we know that this beneficial ownership amendments that came into force April, May last year is to address this grey listing of South Africa and that the money laundering and that we need more disclosure about who actually sits behind these companies, who is the human being that actually controls this company. I think first of all, when you deal with beneficial ownership, always keep in your mind that this distinction isn't always carried through in the regulations, but broadly the distinction is supposed to be between non-affected companies and affected companies. I think that's your first thing that you must keep clear in your mind. An affected company is either a regulated company for purposes of takeover law or a subsidiary of a regulated company. Okay, so that's your affected companies. And then the rest is non-affected companies. Probably the majority of private companies that you will deal with is non-affected companies. This concept of a beneficial owner, this definition that they introduced, that's got to do with non-affected companies. So non-affected companies have to disclose who their beneficial owner is. The affected companies have to disclose or make entries into their register around who holds a 5% beneficial interest in the securities of that company. And what we saw very early on, the CIPC, they sent communiques around this, and it's not supported. It's not, actually, I believe it's not correct, and it's not supported by the text. They then said, a beneficial owner is anyone who holds more than 5% of the shares of the company. And that's that's conflating the principles. The beneficial owner has a particular definition. It's actually a bit narrower than I think what they sought to achieve. But it's essentially, it's saying it's a natural person, it's an individual who owns, don't know what that means, or has effective control over a company. And then they list some various examples of how you could achieve that control through the holding of securities or through voting pool arrangements or through controlling the holding company, etc. But it's an individual who owns or has effective control over a company. And that control in that definition is not defined. So it's not like the definition in section 2 and 3. You're working off the sort of common law general meaning of control. And so a number of issues arise from that. So first of all, it's clear it's got to be a natural person that you're looking at, who exercises effective control, who owns a company, not defined terms. No percentage thresholds are set for this. So a lot of people say, okay, but 20%, what about 20%? What about 25%? All of that. That comes either from overseas. You do see that in some jurisdictions overseas. You see it in some codes that are published, international codes and guidelines and toolkits about how to work out the beneficial owner. It's not in the It's not in the Companies Act. We don't prescribe a threshold. Your general definition of effective control, when does someone actually effectively control a company? At common law, it's very well established. Locally and in foreign jurisdictions, it's the 51% shareholder. The person who holds 51% of the shares is the controller. I guess you could have instances of negative control where your minority protections, perhaps in terms of a shareholders agreement or MOI, are so extensive that it's almost like having positive control. But generally speaking, effective control is someone who has 51% of the shares. And also one thing, and I think this is probably the biggest shortcoming of this definition, is there's no aggregation principles. And that's actually where, when you look at a structure of a lot of private companies, this beneficial ownership analysis just breaks down. Because it's not often that you have one individual, one human being who controls the company. He or she controls that perhaps with family members or through a trust, but you see there's no aggregation principle in this beneficial owner. They don't say someone who, with related or interrelated persons, exercises control over the company. They don't have that. And you can contrast that, for instance, with Section 2 and Section 3 of the Companies Act, where for purposes of determining who are related persons or for purposes of determining which company is a subsidiary of the other, you have to aggregate interests of related persons. They don't have that aggregation principle. And it's also not clear whether management control qualifies for purposes of the beneficial owner. So the question that arises there often is, I can't find a shareholder, a natural person shareholder who has 51%. So what do I write down into the beneficial owner disclosure? Do I just say that it's the CEO? Do I write down the directors? I mean, they control the company in a sense, but that's day-to-day management of the company. It's not correct at common law to say the CEO controls the company. It's not, of course not. It's the 51% shareholder, because the shareholder can reconstitute the board. So I don't believe that management control qualifies. And then also just be very careful, don't conflate the various definitions in the various pieces of legislation. So the Companies Act has a definition of a beneficial owner. That's who you then have to disclose in the Securities Register and file at the CIPC. Then Trust Property Control Act has a similar, but in some respects very importantly different definition for who is a beneficial owner of a trust. The founder and the named beneficiaries and each of the trustees are deemed to be beneficial owners of a trust. It's not the case under the Companies Act. FICA has an even more extensive definition of and more deeming provisions about who is deemed to be a beneficial owner. But that's for accountable institutions when they do their KYC. So all the partners of a partnership, even if they're silent partners, they are each deemed to be beneficial owners. Don't mix that up. So if one looks at an example here, just as a beneficial ownership example, let's say you've got a natural person that has the biggest shareholding, 20%, then you have someone who has 5%, and then 1%, and then 74%, let's say, is held by general public or maybe by institutional shareholders where you're not going to find a natural person. So in that scenario, absent something quite unusual in the MOI or shareholders agreement, there's no beneficial owner on the strict definition in the Companies Act. CIPC's view would be that natural person B and A are natural persons because they hold over 5%. But they're conflating the principle of holding a 5% beneficial interest, which is for affected companies, and then the concept of a beneficial owner, which is for non-affected companies. So in that scenario, there's actually, strictly speaking, not a beneficial owner. You can, out of the abundance of caution, if you want to go above and beyond, disclose perhaps natural person A as the beneficial owner. Some codes and foreign jurisdiction use 20%, 25% in others, but that's not hardwired into the Companies Act. But actually the structure is never that simple. There's always a trust there somewhere, and that's when it gets, so it's never the first one, it's like this one. So often you find this is that your real candidate there for finding a beneficial owner is a trust that has, in this case I've given 51%. So we say, okay, that's an interesting line of inquiry, because that's 51%. So let's have a look there if there's a beneficial owner. Now we know a trust is not a natural person. It's treated as a juristic person under the Companies Act. So that cannot be a beneficial owner. You cannot write down Family Trust A as a beneficial owner of the company. You've got to go and look now behind to see who controls that family trust. But what is the typical structure of a trust? 3 trustees, patriarch, matriarch, independent attorney. There's always the one independent attorney, so there's 3 trustees. All decisions of the trustees, in terms of the trust deed, have to be taken by majority vote. There's not one trustee who can control that trust legally. In terms of the trust deed, he cannot. Maybe there's a forceful personality or everyone listens to what he or she says, but that's not legal. That's not legal control. So you look at and there's no aggregation principle. So now you see, okay, I can't identify an individual who controls this trust. Who are the other candidates? Beneficiaries? Nah, but they're going to be discretionary beneficiaries. They at most have an economic space to maybe receive distributions or something. They don't have control. But don't mix this up, because now under the Trust Property Control Act, yes, named beneficiaries in the trust deed are deemed to be beneficial owners, but that's for the master. That goes to the master's office. That's not a CIPC thing. So beneficiaries, I don't think they would ever really be candidates for purposes of being a beneficial owner. Founder could be. Typically the founder's role falls away after the donation, but that's where you've got to look at the trust deed and see, ultimately you're going to be asking who has the power. Is there an individual who has the power to reconstitute the board of trustees? That's the person who might be the candidate for being a beneficial owner. But if they, and sometimes, with those Isle of Man trusts, I get a lot of those questions. In the Isle of Man, sometimes they have a concept of a protector they have in their law. Protector it would be a natural person who has the power from time to time to remove the trustees, the board of trustees. I would say yes, that actually of anyone there, the candidate for being the beneficial owner is that protector. But it's very difficult with family trusts. So you can see how you can just work around this and circumvent it, and then you'll never have a beneficial owner. And actually, I find most of the time, these companies don't actually have a beneficial owner. So I think they're going to have to revisit that. And then also the most recent communiques from the CIPC, because it's not clear when do you have to make these beneficial owner filings. It's not clear from the Act, but I think it's relatively clear now you do that with your annual return, or if there's a change in the beneficial owner, then within 10 business days after that. Okay. All right, that's my bit. We're going to go through all our sections. We'll have a Q&A at the end, if that's okay, just for 15 minutes. So, okay, that's my bit. I will hand over to Thandi.
Thanks, Yaniv. Good afternoon, everyone. My name is Thandi Wentlapo, as introduced, and I will be taking you through proposed amendments to Section 38 of the Companies Act and Section 40. So there isn't much controversy on these proposed amendments, and actually they're quite welcome. So firstly, for Section 38, I would like to go through some examples just to set the scenario of when you could have irregular shares. So this is a new section that will deal with an irregular issuance of shares. So in the first instance, I have administrative oversight in not filing the MOI amendments regarding the share capital. So this could happen when you're filing an MOI with CIPC and you don't follow the proper process. As you would know that there's a different way to file if you are incorporating the company with a standard MOI, or if you have a bespoke MOI, then you have to do a manual filing. But perhaps you didn't follow that process correctly. And then another common instance is where a company has issued shares in excess of its authorized shares. So say you have 1,000 shares, but you need to issue additional shares that will get you to 1,200 shares. So that can happen, and currently the way it's being dealt with in certain instances is through Section 38, subsection 2, where you issue those shares and retrospectively ratify that issuance because you didn't have enough shares to make that issue in the first place. Another instance would be the terms of those shares not being properly authorized. So in terms of Section 36, all the shares that get issued, they must be properly authorized in terms of their terms and rights and preferences. Another instance could be where Section 41 was not followed. The shareholders did not pass a resolution inadvertently where you were issuing shares to a director or issuing shares to a related or an interrelated person, or following that issuance, you have a shareholder that will exercise 30% or more of the voting rights. The last one is in an instance where preemptive rights are not followed in terms of Section 39 of the Companies Act. And it could also be in terms of your MOI or shareholders agreement where you have a bespoke preemption process that has to be followed. So I'll take you through Section 97 of the previous Companies Act. I'll try to do as best as I can, as I didn't practice under this act, but Ian laughing here in front of me probably did. Actually, he did. And the reason I'm going through this old act is because the proposed amendment almost verbatim repeats the provisions of the section. And currently in our Companies Act, we do not have a provision that deals with an irregular issuance of shares subject to that 38(2), which we don't think really deals with some of the issues. So in this instance, a person had to apply to court for the court to validate the invalid issue. The court had a discretion to validate the issue if it believed that it was just and equitable in the circumstances to do so. And I know the next question would be, what is just and equitable? I think in this instance, we have to rely on case law, and there's quite a number of jurisprudence in terms of cases that were decided under this section. And the court, when it validated this issuance, it could also make it subject to certain conditions, and the court order had to be registered with the registrar at the time, which is CIPC now under our current Companies Act. This application could be made by any person who's interested, and you'll see that similar wording is used in terms of the proposed amendment. So now let's look at the current position under the Companies Act. So as I've mentioned earlier on, there's no equivalent mechanism where you can deal with this issue. And the position is that shares must be authorized in terms of Section 36, and the board can only issue shares that have been authorized in terms of Section 36. So now, as I mentioned, under Section 38(2), this is not really a solution for some of the regular issuances, and the section is not often used. There's also two schools of thoughts, which is worth mentioning, and lawyers cannot agree on this section when it can be used. So the one school advocates that you can use the section if there was an action that took place inadvertently. Another school says that you can use the section deliberately. For instance, even when you know that you don't have enough authorized shares, you can still issue shares in excess and rectify that situation later on. But the issue arises, what happens if you are not able to rectify that issuance which was in excess of your authorized shares within 60 business days? So this is not currently dealt with, which is why the proposed amendment is welcome. Another alternative could be arguing that you can bring the matter to the tribunal in terms of Section 6, but we think this is a bit of a stretch, and I had a discussion with Yaniv on this, and it's probably not the appropriate platform to deal with the issue. So now let's look at what the amendment bill is proposing. So as I mentioned, there's wording which is borrowed from the 1973 Act, and there's going to be a new provision, which is Section 38, capital A. So the court will validate, and not just, I know I've been talking about an issue of shares, but also a creation of shares that was not done properly. So the court will look at two instances. So the first thing is, obviously, there has to be an interested party that brings the application. It could also be the company itself that is issuing the shares that brings the application. And again, the court needs to satisfy itself that it would be just and equitable to validate the issue of shares. So this is a welcome change, but there's a concern that having to deal with the court might seem a bit inflexible, especially with the New Companies Act, where we've moved away from approaching the court for certain things, such as a scheme of arrangement. So in terms of understanding what is meant by just and equitable, we think that it may be worth looking at the 1973 jurisprudence, as there's a number of case law that was decided under the section. And there's a recent judgment as well, the African Legend judgment, which deals with an irregular issue of shares, which took place years before the case could come before the court, and the court was required to validate that issuance. So what we think the court will consider, and this is not an exhaustive list, is if there was a historical inadvertence where the shares were issued and there was a technical omission, and or there's no controversy or challenge with the issuance from the shareholders. There's another provision here which provides that prescribed fees need to be paid, and these fees need to be paid to CIPC. Unfortunately, it is not clear what these fees will be, how much will need to be paid, or whether it will be a normal flat rate that you pay to CIPC when you make changes. So in this regard, it would be helpful to have a regulation that provides some clarity in terms of who's an interested person that can apply and what these fees are. So the next section and the last section I'll deal with is Section 40 of the Companies Act. So there are small amendments here that have been proposed. So Section 40 deals with the issuance of shares, and a starting point is that the board should only issue shares for adequate consideration. So it must receive consideration for the shares that are being issued. And perhaps it's worth mentioning at the outset that the following provisions will not apply to listed companies in an instance where shares are not fully paid up upfront, but you enter into an arrangement where the shares are issued and transferred to a third party and kept in trust. So that will not apply for listed companies because of the JSE listings requirements require shares to be fully paid up upfront. So there is an exception where the shares are not fully paid upfront, and that is where a subscribing party provides an instrument that cannot be immediately realized by the company as consideration, or in an instance where for consideration there's an agreement for services, which is known as sweat equity, which will be realized later in future. So you can still have a transaction of this nature, but it's regulated in terms of how it should be done. So let's look at the rights that would ordinarily attach to these shares, but will not apply unless your trust agreement provides otherwise. And those shares relate to voting rights, preemptive rights, and distributions. So as a default, these rights will not apply unless in your trust agreement you provide otherwise, but in practice, in a number of transactions that we've done, we did the other way around. So the big question in terms of Section 40, subsection 5, which allows you to issue shares for future payment, the big question has been, what is this trust? Is it a trust that is contemplated in terms of the Trust Property Control Act? And our view is that it is not, if properly structured, and Council supports this view. The amendment bill provides clarity in this regard in the two definitions that it has. The first one is the stakeholder, where it sets out who a stakeholder should be that keeps these shares that are held in trust. So the person has to be an independent third party that has no interest in the company or the subscriber. So for instance, it can be a shareholder in that company that acts as a stakeholder. And the examples that are provided in the proposed amendments is that the stakeholder can be an attorney, can be a notary public, or an escrow agent. And another definition that comes with the amendment is the stakeholder agreement. It is very important that the stakeholder agreement is in writing, and this agreement will be entered into between the stakeholder and the company that is issuing shares itself. And that is the end of my presentation. We look forward to the questions later on. Thank you.
Good afternoon, everyone. My name is Akona Mkwaba. Sorry. And as Yaniv mentioned earlier, I will be discussing 3 of the proposed amendments to the Companies Act as proposed by the amendment bills. In particular, these amendments seek to make changes to sections 16, 45, and 95 of the Companies Act. And these deal with MOI amendment effective dates, financial assistance, and employee share schemes. Just as an overview for each of these, I will set out the current position in terms of the Companies Act and the issue that the amendment bill seeks to address and the proposed amendment and its effect. So the first amendment I will be discussing is with regards to the filing of MOI amendments and the effective date of that. And this is a question that we get quite frequently, as there is often some uncertainty as to whether MOI amendments take effect from the date that they are submitted or filed at the CIPC, or once the CIPC has confirmed that the amendment is on file. In terms of section 16(9)(b), an amendment to a company's MOI other than an amendment that changes the company's name, which is dealt with in subsection A, that it takes effect on the later of the date on and the time which the notice of amendment is filed, or the date that's set out in the notice of amendment. Where the confusion perhaps arises is with the use of the word filed in this section. Because if we have a look at section 1 for the definition of filed, it does say that when used as a verb, file means to deliver a document to the commission in the manner and form prescribed for that document. And from this definition, there are some that have taken the view that mere delivery or submission of the MOI amendment to the CIPC is enough, and at that date is when the amendment takes effect. So the interpretation that we tend to lean towards is reading the definition of file in this context along with the company's regulations, and in particular table CR3 in annexure 3 to the regulations. The table sets out when delivery is deemed to have happened in certain instances and to certain persons or bodies, such as the CIPC. And what we've gathered from this table is that you do require some form of acknowledgement from the CIPC once you submit your MOI amendment. And accordingly, the amendment would only take effect once you actually have received confirmation from the CIPC that they have placed it on file. So given that there are these 2 differing interpretations, the amendment bill seeks to address the uncertainty as to when the effective date of MOI amendments actually take place. And to illustrate why this would be important to gain clarity on, you can imagine a situation where a company wants to amend its MOI in order to create a new class of shares or to increase its authorized share capital in order to issue those new shares in terms of a transaction or otherwise. The company would only be able to issue those shares once the MOI amendment has been filed. And so it is important to clarify exactly when this date is, such as to avoid a situation where a company issues shares that are not authorized as at that date. So the bill proposes to amend Section 16 of the Companies Act by providing that an amendment to a company's MOI will take effect 10 business days after the receipt of the notice of amendment if the CIPC, after the expiry of those 10 days, has not endorsed the notice of amendment or delivered a notice of rejection to the company with reasons, or alternatively a later date as set out in the notice of amendment. The effect of this amendment is the effect of the amendment to Section 16, what it intends to achieve, is just certainty as to when the effective date of MOI amendments take place. And this will overall just improve the doing of business and will also avoid just general uncertainty. So the second proposed amendment I'll be discussing is with regards to Section 45 of the Companies Act, which regulates financial assistance to directors and prescribed officers of a company, as well as related and interrelated companies and corporations. And that definition of corporations we think is wide enough to probably include foreign companies as well. So subsection 3 prohibits the giving of financial assistance by a company to its subsidiaries unless it is pursuant to an employee share scheme or pursuant to a special resolution that was passed in the previous 2 years. Subsection 4 further requires that the conditions or restrictions in respect of the giving of financial assistance set out in the company's MOI are satisfied. So the the amendment bill, recognized that this protection that is offered by Section 45 shouldn't be applicable to holding companies providing financial assistance to their subsidiaries, and it just creates an unnecessary compliance burden. But the same cannot be said for a situation where a subsidiary is providing financial assistance to its holding company or to companies within the group of companies. And as such, these would still be regulated in terms of Section 45. So the bill proposes an amendment to Section 45 by adding a new subsection to capital A, which provides that the provisions of Section 45 do not apply to the giving of by a company of financial assistance to or for the benefit of its subsidiaries. And notably, this is not limited to only wholly owned subsidiaries. So the effect that this proposed amendment is that it will also ease the doing of business by eliminating this unnecessary provision that doesn't necessarily provide any protection, but in practice it really just causes some compliance burdens. It is important to note, however, that the definition of subsidiary in terms of the Companies Act only contemplates a South African subsidiary, and so the provision of financial assistance from a South African holding company to a foreign subsidiary would still be regulated by and subject to the provisions of Section 45. So the last amendment that I'll be discussing is with respect to the definition of employee share schemes in terms of Section 95 of the Companies Act. Sections 41, 44, and 45 of the Companies Act contain certain exemptions relating to employee share schemes. And for example, Section 41 sets out instances where an issuance of shares requires a special resolution of the shareholders of the company. But these provisions do not apply to an issue that is pursuant to an employee share scheme. Sections 44 and 45 prohibit the giving of financial assistance that is contemplated in those sections unless it is pursuant to an employee share scheme, as mentioned previously. And Section 96 also excludes employee share schemes from the definition of a public offer. So in terms of Section 95, the definition of employee share scheme is limited to schemes which involve the issue of shares in a company or a grant of options for shares in a company. What is not contemplated in the definition is a scheme which involves the purchase of shares in a company. The amendment bill seeks to extend this definition to now include employee share schemes which involve the purchase of shares in a company. And the effect that this has is that these types of schemes will now qualify for the Section 41 and the financial assistance exemptions that I had mentioned previously. It had been assumed that this was the case already, but I guess the proposed amendment will finally clarify this point. And this is also intended to support the further growth and use of employee share schemes. Thank you very much. That is my section. I will now hand over to Vivian.
Okay, good afternoon, everyone. I'm Vivian. I'm a director in the Corporate Commercial Department. So it's my pleasure to talk to you today about the more juicy and controversial aspects of the amendment. And those are the amendments which relate to remuneration. So obviously, the topic of executive remuneration is a very hot topic in South Africa. It goes without saying, like with the levels of inequality that we have, with the industrial, unrest and strikes that we've been experiencing. A lot of these are actually linked to executive pay and the gap between executive pay and the pay of the general worker. So if you look at the figures for 2023, which were released last year, just looking at the telecoms industry, the total guaranteed package for an executive in the telecoms industry was, the average was 10.56 million rand, whereas a minimum wage salary in 2023 was 52,000 rand. Now, that is a huge gap. So it's a huge gap in South Africa, but it's also a huge gap globally. It's part of the global debate. And I think internationally, a lot of jurisdictions have been struggling with how to deal with that. So just by way of comparative law, for example, in the UK, which was the first jurisdiction that basically started to introduce these kind of say on pay regulations, they put in quite sort of harsh kind of provisions right from the start, referring to a binding shareholders vote. So in Australia, I don't know if you're familiar with that, but there's something called a spill. So there, if the remuneration policy is not approved for 2 years in a row, the entire board has to resign, which is actually, and stand for re-election, which has actually been used as a way to actually kind of do a little bit of a coup of the board in some of the Australian case law. And then France also has a very, very stringent regulation of this, which is quite similar to ours, which I'll take you through. So basically, in terms of this whole issue of remuneration, there really are two buckets of issues. The first is disclosure. So transparency, disclosure, for everybody to be able to see the gaps between the highest paid and the lowest paid. And the second is the say on pay, meaning that the shareholders or stakeholders should have a say on what the members of the board are remunerated with. So I think those are the two broad topics, and you will see that in the amendment bill they've actually kind of separated out those two topics. There's one issue that I do need to highlight, which sent me a bit astray, is that there are actually two drafts of the latest bill. So please be aware of that. There's one that was published in August, and then one that was published in December for comment. And the December draft has quite a lot of changes from the August draft, especially in relation to this topic. Okay, so in South Africa, the first place where this whole issue was picked up was by King. And in King 4, there's quite a lot of detail on this whole remuneration issue, and King, I think, took the global policy and divided it into 3 different sections, which is basically that a remuneration policy or remuneration report would consist of 3 things. The first is a background statement. The second is the remuneration policy, which is forward-looking. And the third is the implementation report, which is backward-looking. So that would enable shareholders and stakeholders to track how the company has actually implemented that. King also recommended that remuneration policy be submitted for a non-binding advisory vote, which and provided that if that non-binding advisory vote was not passed, provided for certain mechanisms to engage with shareholders and stakeholders about why it wasn't passed. Sorry. So King 4's take-or-pay recommendations have actually been adopted by the JSE. So in the JSE listing requirements, companies are required to table a non-binding advisory shareholder vote on remuneration. To the extent that the shareholders vote against the remuneration, then there are obviously sort of mechanisms that these companies put in place to engage with the shareholders. Sorry. So I think some of those engagements have been quite public. And the JSE has publicly said that they prefer this mechanism. Then we get to the actual bill. So basically the bill provides for two new sections, Section 30A and 30B, and those were the ones in the December draft. Previously it was all under one section, Section 30. And this is applicable only to state-owned companies and public companies. So firstly, in Section 30A, we talk about the remuneration policy, okay? So Section 30A provides that the board must prepare the remuneration policy and must present this to the shareholders for vote by ordinary resolution. The bill further provides that this must be voted on every 3 years, and if you do make an amendment, or, which they refer to as a material amendment, it has to go back to ordinary shareholders for a vote. So this is actually very, very significant, and unfortunately, we have noted that there's a big gap, because it's all very well that we have this shareholder approval process, but the key question is, what happens if the shareholders don't approve? Basically, it can put the company in limbo, and they're not able to pay their directors or their prescribed officers. So we've actually made submissions in this latest version, which we sent last week, and we said, look, we understand the policy, we understand that you don't want it to be toothless, but you've left out this fundamental issue about what happens if the shareholders vote against the policy. So the recommendation that we've made is that the consequences of Section 30B should follow, and I'll take you through that. But that really is a big problem, because we wouldn't want to be sterilized from paying directors because of this vote. Okay, then they've separated out the kind of forward-looking disclosure aspects into Section 30B. So Section 30B refers to what they call a remuneration report. Now, the remuneration report consists of three things: background statement, the policy, again, would be tabled, the one that's been voted on by the ordinary shareholders, and the last one would be what is referred to as the implementation report. So the implementation report is a really controversial one when it comes to disclosure. It provides very clearly what must be disclosed in this report, and that includes the total remuneration of each director, public officer, the total remuneration of the highest paid employee, the total remuneration of the lowest paid employee, the average salary, the median or midpoint salary, and finally also a calculation of the remuneration gap, which is the gap between the top 5% and the bottom 5%. So we can kind of see from a policy perspective what they're getting at here. But there may also be unintended consequences of this. So it goes without saying that if companies have to disclose this, they would think very carefully about the lowest paid employee. So in a country which has the employment figures that we have, is this possibly not acting as a sort of disincentive to employment? Linked to that is the whole question of outsourcing. I know people don't like outsourcing, the unions don't like outsourcing, but I mean, if you are going to have this sort of very, very overt disclosure of the gap between your CEO and a cleaner, you would rather employ a cleaning company and subcontract them to clean. So it may encourage outsourcing. It may not encourage additional employment. It may be quite difficult always to get a proper understanding of what the total remuneration is, between the highest paid executive and the lowest paid, especially if the executive, for example, is getting incentives. Look, there are other provisions in the Act that provide for that, and there is some guidance about what total remuneration would be, but there could be a timing difference. And of course, the other thing which is always raised is the South African brain drain and the fact that a lot of skilled people are leaving. We need to try and retain skills in the country, and that this kind of thing would actually disincentivize people to be directors. And sometimes we need to pay dollar equivalents to get the right people in to run a company. The other issues I think that have been raised by various stakeholders, including Business Unity South Africa and others, is that there may actually have been better ways to do this. You may look at your remuneration in conjunction with your turnover, your tax, the tax that the company has paid, the opportunities the company has created. So there may be a lot of other metrics which may have been more suitable or perhaps should also have been considered in the draft. So basically what happens then is that this implementation report, so you've got the policy, which gets voted on every 3 years. The report must accompany the policy with a background statement, and that gets looked at every year, right? So basically, every year that gets prepared, put before the shareholders, and must be approved by the shareholders by ordinary vote. Then this section has a lot more detail about what happens if the shareholders don't approve. It's not particularly well drafted, so I think they could make a couple of tweaks. But basically, they say that if the ordinary shareholders do not vote in favor of implementation report, i.e., they look at the report, they look at the policy, they are not happy that the policy has been properly implemented, or perhaps they could even be, sort of not in favor of the vast gaps that the policy has created. In that instance, the issue holds over to the next AGM, right? At the next AGM, the Remuneration Committee must prepare an explanation, and it must tell the shareholders what it has done to rectify the position. This is very similar to the non-binding kind of process, the non-binding advisory vote process. And also, they must stand for re-election as REMCOM members at that meeting. Then, if the shareholders, having considered the explanation, having considered all of that, don't vote in favor again of the implementation report, or I'm not saying in favor, but approve the implementation report, then a second set of consequences kick in, which is that those members of the Remuneration Committee, who are the directors, say for executive directors, need to re-stand for election as directors, and they are not eligible to be on the Remuneration Committee for 2 years thereafter. So it's almost like a 2 strikes, you're out. You can still serve as a director as long as you get re-elected, but we are going to remove you from the Remuneration Committee for the time being. So again, there's been a bit of controversy about that. Not many people have had the time to look at the December changes, but from what we can see, and the JSE is not necessarily completely in favor of this. Again, this whole thing about changing directors, that you'd have to run the re-election process. You would have to make sure that you have skilled people who can fill those gaps. I mean, I think we've heard like with the SEC, you don't always have a load of non-executives available to stand for these committees. It's certainly not a very attractive prospect now with these sort of heightened scrutiny amendments coming in. So we expect that we'll probably see quite a lot of discussion about this whole remuneration issue on both the disclosure issues, as well as the say on pay issues going forward. And as I've said, there's definitely one big lacuna there that needs to be fixed. Thank you very much.
Okay, thanks everyone. So we'll just have a Q&A session. Is there a mic going? Yeah, anyone who has a question, we'll field the questions.
Yeah, I have a question in relation to the Social and Ethics Committee changes.
Yes.
You've spoken of the public company and the state-owned company, but
Yes.
what if a private company has exceeded the threshold of 500 twice in the 5-year cycle?
Yeah,
SEC becomes obligatory, but we've chosen not to have a Section 94. And how does that connect to the potential changes in REMCO when that particular private company chooses not to implement a REMCO and those members are sitting directly on the board?
Okay, so you're asking about the about this remuneration?
No, primarily the Social and Ethics Committee.
Yes.
If there is no audit committee, you've got, and essentially no non-executives on your board, you now have to do that for social and ethics, but
Okay, look, this is, and you're talking about for private companies
private
that hit the
entities that
500.
exceeded the 500.
Yeah, that has, that's always been a headache for since actually the Act came into force. But so your composition of your Social and Ethics Committee for private companies is not going to change. So that's going to be 3 members, one of whom has to be a non-executive director, and that's always been the difficult one, because the private companies, they're not going to have a non-executive director necessarily who can sit on the board. So either you're going to have to co-opt someone, otherwise the advice is, that I've sort of given is, look, comply as best you can, at least have the Social and Ethics Committee.
Substance
if the composition is not, substance over form, yeah.
And then in
Yeah.
relation to the REMCO elements, what happens if you haven't constituted a REMCO where these decisions are, is that now required?
Yeah, you see, that's the with the REMCO. So they assume, the way it's drafted, it's assumed that this public company will have a REMCO. Look, if you're a listed company, you need to have the JSE requires you to have a REMCO. So it's those public unlisted companies that don't have this.
Or those privates that have exceeded the 500 and have at some point listed aspirations?
Yeah. No, unfortunately, the bill just doesn't. It doesn't deal with that. I think what will happen, at least, is on that 2-strike rule, you lose your position on the board, and you have to stand for re-election. But I don't think those provisions relating to the REMCO can apply.
Then is the inference not that if there's no REMCO and the board is taking that decision as a whole, the whole board is then terminated?
No, look, that's not what's written there. That's not what they provide for. So so that is a gap. We've actually made previously submissions on that, and I really do hope they.
It doesn't seem to make sense that you would impose that from a social and ethics, and then if you're deploying the 3 non-execs, why not make 94 compulsory?
Yeah. So we'll have to see what happen. Let's see if they do address that in after they receive the comments. But yeah, that's a loophole. I actually don't have an answer for you on that. Yeah. Yes.
We're getting a lot of queries from investment companies asking about this beneficial ownership submission. So I think they're all following that 5% rule. But if you look at the strict interpretation, you don't look at CIPC's guidelines, what are you advising your clients if there actually is no beneficial ownership? So you have the structure where you have no one person controlling, and then you have a trust, and then nobody controls that, and an offshore company which is controlled by another trust.
Look.
Do we just not submit?
So I understand the CIPC updated their system some time ago. They sent a lot of communiques on this, but they said, okay, now you can make a filing that you don't have a beneficial owner. Then you just file that you don't have a beneficial owner. The Companies Act doesn't insist that there must be a beneficial owner. It's just saying if you have a beneficial owner, then disclose it. Maybe the drafters assumed that in almost all cases that there will be a beneficial owner, but the way they drafted their definition doesn't achieve it. So my advice is you stick to the text in the Companies Act. That's what's binding. That's the law. That's how I advise it. So that's how the analysis, I think, should be done. Yes, I think here or there first. Yeah.
Thank you. Can you hear me?
I can, yeah.
I'm not used
Yeah,
to
there you go.
talking to
That's
them.
good. Yeah.
Yeah, thank you, man. The first question is in respect of Section 45,
Yes.
the amendment excluding the holding company from compliance. And when you look at the definition of related, it does not have any exclusions currently. And would it contain such an exclusion going forward? Because it
Yeah.
seems to be inclusive of everything within the group.
Yeah, yeah. No, I see your point there. I don't know if you wanted to. It's so that's the okay. So that issue there is you picked up on a good point there. Is the exemption is for subsidiaries, okay, which is a very particular definition, which means if you hold more than 51%, you have to hold more than 51% in a company for it to be a holding company and subsidiary. Related is a bit wider than that. You could be related companies because there's an element of control. For instance, I have negative control or material influence over the policy of a company, but I might not be a subsidiary. But in that case, unless I'm a subsidiary, I don't have the benefit of that exemption. So they didn't. So as Akona spoke to, the exemption is for subsidiaries. The way subsidiary is defined is it's got to be a South African company. It actually doesn't extend to foreign subsidiaries. But other financial assistance within the group, other related companies, so sideways financial assistance, subsidiary to subsidiary, or subsidiary up to holding company will still be regulated. And this was probably not intentional, but if you're related, if it's a controlling company that is financially assisting the controlled company, but they're not subsidiaries. Okay, they might not be technically subsidiaries. There could be other form of control. That financial assistance is not carved out under Section 45. It'll still apply. So that was a bit of oversight on their part. Does that answer your?
I think I have answered.
Yeah.
Maybe moving to the next one.
Yes.
I think it was Tandiwe who was dealing with the amendments in respect of the issuing of the shares. There is a statement that she made, which she said in the new amendment, the court would validate the unauthorized issue of the shares. Then when you look at the current position, shares are issued by means of a resolution. Go to Section 218. It says no resolution, MOI, or provision of any agreement shall be void unless ordered otherwise by the court. So my question is, does this amendment not reiterate the already existing 218 position? Thank you.
The mic is off. It was off.
So my understanding of the proposed amendment is not to give effect to something that would not comply with the Companies Act to begin with. I think you mentioned resolutions. So a process still needs to be followed in terms of the Companies Act, and the court would only validate it if it is just and equitable, and there would be factors that the court takes into account. But if, for instance, there was a deliberate intent in not passing resolutions from the shareholders or getting those resolutions approved for shareholders, I don't think that is an instance where the court would validate that issuance, if I've understood your question.
Yeah, if I so if I could just add on to that, you referenced the 218 sub 1, which basically says a resolution or a transaction is not void unless declared void by a court, unless the specific section says it's void. So, but, for instance, Section 41 is an example where certain issues of shares require special resolution, but it doesn't say it's void if you don't comply with it. The issue with 218 sub 1, it doesn't really help you a lot. It just creates a sort of some comfort in the meantime, but the point is So it says until a court declares otherwise, but the point is, if it gets to court, your risk is that the court is going to declare it void. So then it doesn't help you, 218 sub 1. And that's where this new section 38 cap A will kick in to say, okay, even though it was a void issue and is perhaps declared as void by a court, we then reverse that voidness or expunge that voidness through another court order. Yeah, so 218 sub 1 kind of helps, but it's more of a procedural, it's almost like a presumption that helps you until there's a court order. But the problem is when you get to the court order, it's void, and you need this 38 sub A to help you. Yeah. Yeah.
Thank you very much for a very, very good set of presentations. I really enjoyed it.
Sure.
Have you given any thought to the application of remuneration disclosure in the context of a group? The Companies Act talks about the company. I don't think this is something that, from an IFRS perspective, would go into consolidated financials, I'm expecting. So there's a lot of theory, but in practice, I expect that many listed companies simply have no employees. Yeah, that's the question.
Oh, I see what you're saying at the group. Yeah, if you look at an individualized, the holdco is not the operational entity that has all the employees. Yeah, no, so yeah, they don't deal with it on a consolidated basis. Yeah, that's a bit of unintended. Yeah, that's a fair point. Yeah, I mean it's not dealt with on a consolidated basis. In those next, it's the company. Yeah.
Yeah, that's right. So it doesn't actually say, it doesn't contemplate a group. Look, it's public, it's state owned. So I suppose the listings requirements would apply to those that are listed. So I don't think you would get away with it there. But that could be quite a neat little maneuver. I agree. Keep the holding company and have all the employees somewhere else.
Yeah. The answer is no. I don't think we really thought that one through, but good. We need to. Yeah. Any other questions? Yes, Hugh.
Thanks, Annie. Just to mention, but with support to your point about relaxing time bars, in the construction industry, you've got several well-known standard form contracts, one of which is FIDIC. The latest edition, 2017 edition, gives power to the adjudicating body to extend the time bar. And I think, again, the wording is on good cause shown. So there's support.
Yeah, there's analogous areas. So we will probably, in now applying this new sub 7, we'll probably draw from that, like I mentioned, Pickford's case, that was the competition case, and then Salmon Core was the arbitration. A lot of people don't know that when you have an arbitration clause, where you have an arbitration agreement in your contract, like sale of shares or sale of business, and you've written, for instance, you can't bring a claim for a breach of warranty, say after 5 years. You put a 5-year time bar after you sign or close. The court can actually override that. They can actually remove that time bar on good cause shown. For instance, if you've only discovered your the material facts later. It was sort of a hidden, very latent type of damages. And so that type of thing, I think, will now apply to these claims against directors. Similar type of thinking, yeah.
Do you see any impact from 77 sub 7 changes in regard to the D&O insurance cover and maybe the insurance industry taking a dim view on that?
Yeah.
Can we look at increased premiums coming along?
I wonder if they even, it's quite a nuance, it's a very subtle point. I wonder if insurers, I mean, that's a fair point. I wonder if they actually even knew or thought about this, because it's very easy to read that 77 sub 7 sort of glibly and say, oh, okay, but that's prescription law, so what's new about this? No, actually, it's very significant because it differs materially quite a bit from prescription law. So, yeah, fair enough. I mean, that's a fair point. Maybe they will now latch onto this when they didn't even think about it and say, oh, actually, we had a very good position previously, a very nice technical way to wriggle out of having to pay under the insurance. Now maybe, fair enough. I wonder if they have really applied themselves to this, but it's a fair point. Could be. Yeah, could be.
I just have a question on the beneficial ownership. So
Yes.
obviously under the trust, under FICA, under the Companies Laws Act, there's, it speaks about beneficial ownership, and we get a lot of questions coming through from the banks or other entities asking us for this information. So we're actually controlled by a global company overseas, and we don't actually have a natural person that's controlling our entity. So in terms of FICA, do we also say this, or is it a bit different?
Yeah, but you see, okay. No, but FICA, that is a bit of a different, there's a lot of deeming provisions. FICA, as compared to the Companies Act, FICA very importantly has one sort of catch-all, sort of a fallback position, where if you can't identify the beneficial owner in the normal sense of like a controlling shareholder, someone, you write down who the senior executives are. I think they say senior management, which is not under the Companies Act, and actually that's not normally who you would say controls the company. So I think in your instance, you would say it's the senior managers, CEO, CFO of the company itself. It's not clear whether that extends up to the holding company if you have one, but I think for those companies that end up with a very dispersed shareholding right at the top, you'll probably find they have to default to the executive management, and then maybe you would have seen the FICA released a draft. I think it was last year, a sort of a guidance on how to identify beneficial owners, and they want to use, I think, 25%. It's not actually supported by the legislation, but I think it's just a practical toolkit that they've rolled out, whereby you will multiply through, and it'll be like a multiplication. So if I hold 50% of a company that holds 50%, I'm 25%, and then I'm the natural person, which I think on normal print, just on the text of FICA is not correct, but I guess you have to work with something, and a lot of people just apply that guideline. Yeah.